Hello everyone, this is Desi Vijay. I'm a national team member and a coordinator for webinars for North-South Foundation. Glad to see you all here today. Today we are simulcasting this session on our YouTube channel. So welcome to the session through YouTube channel too. Let me also wish all of you here a happy 4th of July. And also, good luck with the Indian team with the finals. We had a few interesting sessions thus far in spring, summer session, and thank you for your all support. But we are today going to have a very popular session for the request of many of the earlier participants of our webinars during the last similar sessions on the personal finance. We are also having an attorney joining us along with the familiar financial advisor here to talk to us. I'm really glad that we are able to bring this live today, and welcome to yet another exciting webinar. However, before we proceed further, let me get the usual housekeeping comments out of the way. We are recording this webinar as we speak, and since it is simultaneously broadcast in YouTube channel, the recording will also be there once we are done. Some of the past webinars are also available in our North-South YouTube channel. Please look for them, subscribe to the channel, and then watch them at your leisure. If you have any questions you want to ask the speakers, please type them out in your questions or chat tab. The listeners who are in the YouTube also type out in the chat their questions in the chat. We have a monitor, a volunteer monitoring that channel, and then he will post the questions for you. We will ask the speakers on your behalf all the questions you want to answer, but please don't keep posting the same over and over again, because it makes it harder for us to go for the really new questions. We will try to answer all the questions, but we would like to limit the session also to 90 minutes. So hopefully we would by that time answer all your questions, but if you think your question was not asked, you are free to contact us at webinars@northsouth.org or any of the presenters for your with your questions. Thank you for understanding. And also, before you leave, take a moment to fill in the feedback questions. And this has been important to us in the past, and it will be useful for the presenters too. We really appreciate your help in this matter. Thank you for listening. Let's move on to the scheduled program. Today we are going to talk about wills, trust, and probate. Very popular topic. We have a very enthusiastic and accomplished lawyer and a financial advisor amongst us to talk to us and share their knowledge and experience with us. This is purely educational only, so there's no commercial interest involved in this. Let me first bring in Jyoti. It gives me a great pleasure to welcome Jyoti Sherahati and of course Don Bug as presenters of today's session. Jyoti is known to us as she has presented a couple of sessions last year and been familiar with our audience groups. And she's a licensed financial planner and a marketing director. She's based on Chicago, and she has been advising many families on personal finance and conducted numerous educational seminars through various organizations and communities all over this country and also in India. So on your behalf, let me welcome Jyoti, who will make her small presentation or talk and then introduce Don to all of us. Here you go, Jyoti.
Okay, thanks Vijay, and thanks to NSF, for allowing us to present this webinar. It's very important, a topic on this one. So because many people, we are not aware of it, why we need to do estate planning. I know many times when I talk to families, they said, "Oh, I don't have estate to do estate planning." So not understanding, because we come from India, we never knew we need to do this, in this country. So, I've been there here for 20 years, last 20 years. I'm now not educated on this topic. And when things comes, when families ask me, and when happened, right, then, oh, I didn't know this one. We should have done it. That's what all the question, when it happens, they always come back to me. So that's what, I would like to give more education on this, will and trust is something everybody needs to, one or the other way. Everybody who turns adults, they need to plan it. It protects us, our money, our kids, our family, not to go to the probate. Of course, Don is going to be more experienced, and Don has been helping our community, and also a lot of my clients is always there. Whenever we always have a personal link with him, and then he shares the knowledge, and he's been booked many. Of course, you guys, if you need to talk to him one-on-one, it's all 30 minutes free consultation with him. We can organize. And then this organization, they do work across the USA. It's not just one state, so they are licensed with many states as well. So if you guys are wants to, after this session, wants to set up a 30 minutes free consultation one-on-one, you can let us know. We will arrange a session for with him. And also they do work with other plannings also, like international planning, tax planning strategies, and they do special needs kids, all different kind of strategies they do, not just one plan fit for everybody. Again, business owners has a different solutions. And I am been doing sessions on different topics, as we just said, right? Retirement planning, long-term care, investments, college planning, visitor insurance, and even medical insurance. People who come here, either they visiting here, or they have a green card and then they're retiring, what type of health insurance they need to find, right? So much confusion, right? So I do the bring the education to the table, and then guide them. Okay, these are the things you need to lay it out. And we do have a webinar, so I do have my own WhatsApp community channel where I post these different topics webinars. And also we have a group for just to talk about the estate planning. I'm going to share with Vijay. He's going to share with you guys. You guys can join and discuss about anything you want to discuss. If we cannot answer during this session, please feel to join and get educated and take action, right? So many times we do this education because we want you to be take care of it. Take action, and then take care of your kids and family. So that's with that, I would like to invite Don being so gracious. Over the many attorneys doesn't work weekends, right? When I ask for us, this is the only way, Saturday will you available, he's ready to do it. Even all attorneys, they said okay, Monday to Friday only they can do it, but he's willing to come with us in a weekend. I really appreciate Don coming for us. With that, Don, over to you. Thank you. Thanks everyone for joining. Yeah.
My turn?
Yes, your turn.
Okay, great. Okay, so yes, I'm Don Bug. I'm very pleased to meet you all, and of course, yes, thank you for the kind words, Jyoti. Nice to see you again. I am from an organization known as Inherit Guard, and then there is a law firm that works with that that organization called Estate Plans USA, and I have a sort of a relationship with both of those organizations. I'm going to share my screen here, and let's see if. Okay, does that seem to be showing properly?
Yes, yeah, we can see.
Okay, great. All right. So I'm going to talk a little bit about one aspect of estate planning, and that is trusts of a fairly basic nature. Okay, there are wills, there are trusts, there are a lot of different tools in estate planning, and there are a lot of different kinds of trusts. There are life insurance trusts and charitable trusts and all kinds of things like that. What I'm going to be focusing on today mostly are the very simple trusts, simple simple revocable trusts that meet the needs of many people, probably most people. However, there's a range of things that might serve you or people you know or work with best. So that's our focus today. Now, just a little bit about Inherit Guard. Some information. We have licenses at many of the states across the U.S., not all yet, but we're working on it. We have some service available in foreign languages, and a lot of so just a few facts about us there. Okay, now So yes, today I'm talking about basic estate planning. This presentation really is about doing simple trusts for people who have fairly simple estates. Okay, you may need something more complex. You may need some tax planning. You may need some organization and so forth. If you do, it's right to get that, even if it's a different price, more expensive. You don't want to try to cram a need into something that doesn't meet that need. Okay. So first of all, why do we do trusts at all? Well, a trust is a legal entity that can own things, right? And so why are we creating that instead of just creating a will? Well, if a person dies with no will, being intestate, that's really messy, and I don't recommend that at all. If you die with no will, then your survivors have to make a big inventory of everything you have. They've got to get to a court. They've got to get an appointment with the court for probate. They've got to ask the court to appoint one of them or someone to distribute things according to state law. They have to figure out what the state law says. If there are children involved and they don't have a guardian named, then that can be a mess. It can involve some at least temporary foster care. So I don't recommend that. Now, if you have a will, okay, you've made a big improvement. And I really like wills. Wills are wonderful. I write hundreds of wills. But if you have a will, in most cases, unless your estate is very, very small, there's still going to be some of that probate process in the court. Now, the last information I have about this is getting a little old. I'd like to update it, but the last information I have is that right now in most parts of the country, probate appointments are being set 3 to 9 months in the future. So it can take a long time just to get started. And I've spoken in the last year with 7 clients who told me about still being in probate after 2 years. So I don't think it was designed to be terrible, and it's not always terrible, but when it's bad, it can be really bad. It can take a long time. It can take a lot of effort, and sometimes it gets very expensive. So if you have a way around probate, that's a wonderful thing. Well, a trust does that for you. Okay. When you have a trust, the government basically treats that as a private thing. They really don't involve the court system much, if at all, and therefore your survivors can move forward quickly and with finality on distributing the things that you have left behind you. Okay. So as I mentioned earlier, a trust is a legal entity that can own things. You could think of it as being similar to a company. It's not the same, but there are some similarities there. You create this trust, and then you take property that is yours, you make it property of that trust, but you still control it. As I mentioned before, most of the trusts we create, and all of the basic trusts that I'm talking about here, are revocable trusts. So just like it sounds, you can revoke it. You can also make changes to it as much as you want. You can put property into it and take property out of it as freely as you want. Okay. You are the trustee. Now, because you have that control, there are some things that it won't do. A revocable tax isn't going to change anything about your taxes, though that will stay the same. It's not going to change anything about whether you are vulnerable to a lawsuit or a creditor. That stays the same as it is. Right? Doesn't make it worse, it just doesn't change it. But it does help you avoid probate. It helps you distribute your wealth, determine how that's to happen, sometimes with great specificity. And it lets you choose who will do that and how they will be replaced. Okay. Did we just go up? Yes, there we go. Now, if you are married, then that makes a difference in some things. First of all, when we create a trust for married people, it's usually, not always, but it's usually a joint trust. And so in a joint trust, you're both trustees. And then when one of you passes away, the other one can be the sole trustee. And then when you're both gone, you have someone else that you've designated to become your successor trustee. If you're married, your state's laws probably say that any property that you have acquired during marriage is marital property. In other words, it's divisible if you were to divorce, for example, by a court. Both spouses have a share in that. That includes things that are titled only in your own name. Like if you buy a car while you're married and it has only one name on it, well, it's still marital property. It's still divisible. That's true for a home as well, for things like that. And almost all states have a minimal spousal share. So You can't just disinherit a spouse. You can't just say my spouse gets nothing. I mean, you can, but your spouse will be able to contest that, okay, and get a minimum share. Now, when we do these simple trusts that I'm talking about, both spouses are trustees, and then the property is left to the surviving spouse and then to the children or other beneficiaries you might have besides children. One thing I mentioned, you know, not just the home, but actually, even if you had a home before you were married and it's your separate property, in some states they will define the equity that you acquired during marriage as being marital property, even if you're the only one who was paying into it. So, okay, now in about children and grandchildren, in a simple trust, we leave things to children, and that's usually in equal shares. Okay. Now the usual method for that is called per stirpes, and that's a Latin term. I just learned a few weeks ago this Latin term means by branch, and so what it's saying is if you pass away, let's say you are married and you and your spouse pass away, if a child is living, that child is going to receive his or her share. But if that child has died before you are at the same time, then that child's share will go down to his or her children in equal shares, if there are any, or even down another generation or two or three, or however many. If that child has no living descendants at all, then it will be shared among the other children or the other beneficiaries that you've named. Okay. Now, so we usually leave things to children in shares like that, but you have flexibility with that. You don't have to make the shares equal. You can say, well, this child gets 40%, this child gets 20% if you have a reason to do that. You can include people other than your children as beneficiaries, as percentage beneficiaries of your total estate, right? So you can say, when we're gone, everything gets totaled up, everything gets valued, and then a fourth of it goes to this person, a third of it goes to this person, however you want it to be. And it can be children, it can be other people as well. Now, besides that, you can also do specific distributions. A specific distribution is saying, before all that valuing and dividing goes on, before you do that, off the top, I want you to give, say, my chess set to Uncle Bill. I want you to give my piano to cousin Gladys. I want you to give this much money to my favorite charity. When you're done doing those things, then that's when you start valuing everything and dividing it into shares. And you can do specific distributions of that nature in two different ways. One of them is to do it in the trust itself, and one of them is to do it in an accompanying document known as a personal property memorandum. Now, the reason you would do it in the trust is if it's something that has a title, like a piece of land, right? Or if it's something very valuable, you know, you got a $10,000 necklace, you're going to want to put that in the trust, the language of the trust that says this person gets this. If you change your mind about that later on, you need to do an amendment to your trust. Amendments aren't terribly expensive, so it's not that big a deal, but you do need to do an amendment. Now, for other kinds of things, you know, your furniture, your coffee table, your encyclopedia, your Hummel figurines, whatever that might be, things of that nature, you can do a personal property memorandum. And when we create trust packages, we create one of those memoranda for you to use, but it's for you to fill out. You just fill it out if and when you want to. And you say, okay, this person gets my catcher's mitt, this person gets my china. And if you change your mind about those things, you just do a new one with a more recent date. You store that with the trust, and the trust refers to it. It says, if I have a personal property memorandum, go do what it says first, and then come back and continue. So that's kind of a nice thing, because you don't have to pay a lawyer to do an amendment for those things, and you can think about it and change it whenever you wish. Okay, so we create trusts, wills, and so forth in order to be prepared for when you die. So what happens when you do die? Well, if you are married and you have a joint trust, then your spouse is going to become the sole trustee of the trust. Okay. When you're both gone, your successor trustee takes over. This is someone you've chosen to take over and administer the trust and distribute things according to your instructions. Now, I talked before about how when you have a revocable trust like this, you can change it anytime you want, but the new trustee can't. The new trustee has an obligation to do what you said to do in it. Okay, it has a legal obligation. So the trustee pays debts and taxes, it divides the property and everything, and then divides it up into shares for your beneficiaries. Okay. Now, what about children? Sometimes people have children who are still minors, right? And in fact, even some adult children are people that you don't necessarily want them to receive everything at once. So if a child is still a minor, what's going to happen is the successor trustee will control that child's share, will make distributions, will make decisions to distribute from that child's share for health, education, maintenance, and support. But the child can't take something out himself. He has to ask the trustee, right? So, trustee, can I have tuition? Yes, here you go. Trustee, can I buy a snowmobile? No, you can't do that. However, as a child gets older, as a child passes into adulthood, you may want that child to take control. Now, sometimes people have amazing children and they just say the moment they're 18, yep, they can take full control of all of it. That's great. But sometimes people feel like, gosh, when you've just barely become an adult, I'm not so sure I want that child to get control over all of it all at once. So something that's very common to do, very popular to do, is to set up a system of withdrawal rights that are tied to specific ages. So an example of that, let me just give you an example. These don't have to be the numbers, but you might say something like this. When a child reaches the age of 18, he or she still has to ask the trustee, can't take anything out on its own. And then maybe when the child reaches 21, say, that child can take out up to a fourth of what's in his share, even if the trustee doesn't want him to. Has the right to control that much of it. And now bear in mind, all along, the trustee can make distributions. So if the child needs something, the child can get it. It's a matter of how much the child controls it, him or herself. Okay. So in this example I've given, at age 21, okay, the child can control a fourth of it. And then maybe then at age 25 can control another half of what's not already subject to withdrawal. And then perhaps at age 30, the child can take out all of it if he or she wants to, could control all of it or become his or her own trustee. So that is a system at which under which you can let a child take control, but let the child do so gradually as the child matures. It also keeps your successor trustee from having to do the job forever, right? Now, there is an option with this too, when you're leaving things to children, to have a common trust until all the children reach a certain age, and then have it divided up into shares. Or you can just have it immediately divided into shares. Now, you know, if you die, you've got, say, 3 children, and the moment you die, you have it all divided into 3 shares, that's fine, okay? And that's a very fair way to do it. But the reason some people do it another way is this. It more closely resembles what you can do as the living parent. You have a certain amount of money, and you use it to help your children, but you don't have any special obligation to spend exactly equal amounts on them, right? You don't say, well, you needed braces and your sister didn't, so she gets a pony. Okay, you don't have to do that, right? You just spend as you need to. And so if you want to give your trustee the same flexibility, you can create a common trust. And then when the youngest child reaches a certain age, might be 18, something like that, then everything gets divided. So those are both very valid options. It just depends on your judgment of, excuse me, depends on your judgment about what's going to be best for your family. Okay, now here's an interesting thing. What if you're all gone? Let's say you're leaving things, let's say you're married and you're leaving things to your children, or this could be something else. You might be single and leaving things to your cousins or whatever it is. But if everyone's gone, if you've died, maybe your spouse has died, your children have died, and everyone you've named as a beneficiary has left no living descendants. Obviously, you have a very large family, that's less likely, but it can happen to anybody, right? So if that happened, what happens to the property in your trust? Does it go to the state? Almost never. What you can do, first of all, is you can say, okay, if we're all gone, we name a remote contingent beneficiary. Okay, and that can be a person, or it can be a charity, or it can be more than one person, or more than one charity. It can be any combination of those. Okay, so however many people and charities you want to name to receive what is in your trust in the event that you're all gone. Now, if you don't choose anyone, that's fine. The trust will just say it goes to whoever your heirs are under the law, and then they're going to look at the state law. They're going to look at your family tree and figure out who the near relatives are and whom it should go to. Instances of something like that, a sheeting to the state, are extremely rare. It would have to be impossible to find anyone related to you, so that's not something you need to worry about. But if you want to have control over it, you want to name someone, then you can do that. All right, now when we create a trust package, and this may be true for a lot of other organizations, but when we create a trust package, there are several other documents that are included in that package, just all at one price. One thing we do is we do a general financial power of attorney for you, or if you're married, one for each spouse. That power of attorney is saying, if I become incapacitated, I'm unable to act for myself, then I give this person power over all my money and all my property, just as if it were me. Now, what we usually do there is name the spouse first, if there is one, and then if the spouse is unable to serve, then we name whoever you've named as your successor trustee, because that sort of makes sense. It's the same person who's taking over your estate. Okay. By the way, for any position like that, your successor trustee or your attorney in fact under a power of attorney, I recommend that you name a person and then at least one successor person, one backup person, because you don't want to just have, oh, something happened to us at the same time maybe, and so now suddenly there's no trustee. No, you want to have a backup there. You can do joint trustees, by the way. You can say, instead of saying this person is the trustee and then this person, you can say, well, these two people are trustees together and they have to agree. And then if one of them is gone, then the other one can act alone. Okay, so that's also a possibility. Now, we also do some healthcare related documents. There's HIPAA authorization. Sometimes this is just built into the other documents. HIPAA authorization is you saying, I give these people I've chosen the power to see my healthcare records. There are medical powers of attorney. These go by different names in different states. But the medical power of attorney is kind of like the other attorney. You're saying, if I become unable to make and communicate my healthcare decisions, then this person is going to make all those decisions for me. Now, sometimes people name a spouse first, and then maybe someone else as a backup if you have a spouse. But you don't have to. Some people make the opposite choice of that. They think, gosh, under that kind of emotional pressure, I don't want my spouse to have to do that. I want someone else to do it, and that's perfectly fine. Okay, you can do it however you want, and if you're married, you don't have to name the same people as each other for this. So you're creating that medical power of attorney. In addition to that, there's a living will. A living will is a document, and again, sometimes these are actually combined, but the living will or the living will portion is your direct instructions to your medical providers in the at the end of your life. Okay, so you're saying, if I'm in the hospital and I'm unable to tell you what I want and I'm definitely dying, at least 2 physicians have agreed that I'm on my way out. I'm not going to make any kind of meaningful recovery from this. Under those circumstances only, I want you to do certain things and not do others. So the things to do might be, all right, give me water, give me medications that will relieve pain, even if they shorten my life. The things not to do that you're instructing under this document would be, don't give me medications that are just going to make me suffer longer. Don't continue indefinitely using machines that keep my body going. Okay. So that's what a living will is about. Now, in addition to that, there's also a will, a last will and testament. And this is a special kind of will. It's known as a pour over will. It serves as a backup to the trust. What it says is, when I die, if I have property that I didn't get into my trust somehow, if there's something that I missed, or I didn't have time to put it in my trust, or you're not sure I put it into my trust, but I definitely didn't give it away by some other means, then I leave everything to the trust. So it's designed to pour over from your estate into your trust. Now, you don't want to rely on that. You need to take steps to put things into your trust once you've established it. But it's there at the end to say, just in case we miss something, sweep up the crumbs, get it all out of probate, get it in the hands of my trustee, and subject to the terms that I've set. Okay. If you own your home, we will do a property deed for that home. And so that you sign that at the same time. And once you have signed your trust papers and the trust has come into existence, then you can go and record that deed with your county government, and that will make the home and the land its own property of your trust. That's also included. Additional deeds, if we need to do more than one, are more. They're more money. Now, the concern of having children, of having a guardian named for children comes up. And the documents that we talk about here are really the ones that include your instructions about that. The will, it's usually in the will and usually in the powers of attorney. And say, if my children need a guardian, I name this person, and if not this person, and so forth. All right. So what's the process? Well, your agent, the person who invited you to this meeting, will set up an appointment with me or with someone. It actually may not be an attorney, it may just be a processor. Okay, but they'll talk to one of us, and we'll ask you information. We'll talk to you via Zoom, and we'll ask you, who's going to be your successor trustee? What if that person can't do it? What about guardianship for your children? What do you want to do there? Who do you want to name as your medical decision maker? Are you making all the shares equal? Are you including people other than your children as beneficiaries? Are you going to do any specific distributions in the trust? So we cover all those things. And then we take payment. Now, with a custom trust, it's more, but we still follow basically the same procedure here. We get that information from you and we take the payment. At that design meeting, we do that, and then we create your documents. Those documents are sent out to you via an email. You get a PDF attachment. You look at those. Those are reviewed by someone who's licensed in your state, but then we send them to you for review. You take a look and you see whether it looks like it's doing what you want. You see whether we spelled all the names right and so forth. If you have concerns about it, if you have something you don't understand, if you have something you want to change, we normally don't have a second meeting when we're dealing with basic trusts, but for these you can reach out via email. So for example, you talk to me and then I send you your documents, you look at it and say, wait a minute, I changed my mind about this. You go ahead and get in touch with me via email and we'll make those changes for you, okay? Now, once the documents are good to go, once you are happy with them, then you let us know that, okay? And you get to print the documents, okay, if it's a basic trust. And under those trusts, you print the documents. It's probably going to be, it's going to be more than 100 pages. It may be around 200, depending on how sizable your family is and a lot of other things, but it's going to be a lot of pages. So you probably want to go somewhere like Staples to do that sort of thing, right? And one of the things that keeps the cost down, because this is such an inexpensive plan. All right, so you've printed the documents. At that point, they're ready to be signed and to be notarized. You have let us know that the documents are final, and so we arrange our mobile notary service. The notary gets in touch with you and comes to see you at home or wherever you wish. You need to provide 2 witnesses who are not related to you and not anyone you've named to do things in your documents. Okay, so if this person is going to be your successor trustee, can't be your witness. You hold a signing meeting. You sign, your witnesses sign, the notary signs and stamps everything, and at that point you have valid documents. There's a valid will, there's valid powers of attorney, and there is a trust that has legally come into existence. It's been born. That's great. You're seeing the light at the end of the tunnel, but there is actually one more phase to this, and that's called funding your trust. And this, again, this is for you to do, okay? We give you funding instructions on how to do this. Funding your trust means putting property into it. And so, for example, I talked earlier about how we do a deed for your home. Well, with that deed, you take that to the county, you record it, and that makes your home and the land it is on property of the trust. Sometimes it comes up in these presentations, the question comes up, well, what if I own real estate in another country? If you do, chances are that can't go into a US trust. It's very difficult for a US will or trust to reach out and control land in some other country. Well, what you want to do, though, is talk to an attorney in that country about setting something up. Now, I can think of just one example so far I've seen where there was somebody who had property in the Netherlands that apparently their Dutch attorney told them that they actually could assign to their US trust. that's fine. But talk to that attorney from that country. Okay. You can ask us to do it, but what we will do is just hire an attorney from that country and then charge you extra. So you're better off doing it yourself. Now, with regard to other kinds of property, for example, with life insurance, you don't necessarily need to make the trust the owner of the policy. You can make the trust the beneficiary of the policy, so that those life insurance funds are flowing into the trust when you die. And that way they're subject to those conditions. For example, have you set up withdrawal rights at certain ages for children? If so, yeah, you're going to want to have the life insurance passed that way so that it's subject to all those terms. Okay? So this is always a matter of either making the trust own something now or making something flow into the trust after you die. With your bank accounts, you can talk to your bank, show them a little certification of trust. It's usually 2 or 3 pages. And it's just the basic information about the trust, because the rest of it's none of their business. And you say, when I die, or perhaps when we both die, I want this account to be payable to my trust. So when you're done, your trustee can show up and say, here are the death certificates. Here's what says I'm the trustee. These accounts belong to the trust. I want you to give me the funds to distribute. So we can do that with a lot of different things, and we give you instructions on how to do it. Your advisor, the person who has brought you here and who's working with you, is going to be probably supporting you a lot in that phase of funding your trust, making sure you are helped to do that. If you get confused about something though, and your advisor is also stumped, I haven't seen this happen yet, but if that happens, you can always come back to us and I can try to find you an answer on how to get it in, okay? Interesting concerns about vehicles. You can put a car into a trust, that's perfectly fine. But many people choose not to. And there are basically 3 reasons for that. The third one is the most important. First of all, you want to make sure that your car insurance company is not going to raise your rates. Second, you may find that people at the motor vehicle division or department are unaware that you can do this, and they can be very uncooperative. But the third one is the biggest, and that is that if you're driving that vehicle and you get into an accident and you are exchanging information with the other driver, and the other driver sees that the car is owned by a trust, sometimes those words make little dollar signs light up in their eyes, and they think, oh my goodness, a trust. There must be $1 zillion in there. I'm going to sue the living daylights out of these people. So that problem can come up. And so because of that, many people choose to follow an alternative procedure. Most states have a way that you can put right on your car's title that this is the beneficiary on death. This person receives the car when I die. Or there are other procedures that you can go through that do it still outside of probate, but don't require signing your trust. So that's an option. Both options. Now for inherit card, our basic trust plan is $1,197. These are the prices. If we need to do more than one property deed, we charge $150 for each deed after that. If you own a limited liability company, okay, we can assign your company to the trust. We do an assignment of interest. We normally charge $250 for those. Sometimes people have guns. They have a significant number of firearms, or they have special firearms that are restricted under the National Firearms Act, or antique weapons. Sometimes there's a need there for a gun trust, which is a separate thing, and those start at $600. You can do powers of attorney if children are adults and they are willing and want to sign powers of attorney for financial and or medical. They can do that, and we can tack that on. It's usually $200 or $300 per person, depending on how many documents we're dealing with. When you have established your trust, there are not ongoing fees for maintaining your trust. Your trust exists, so you don't have to keep making monthly payments to us or anything like that. Okay. Now, as I mentioned before, I've spent this presentation talking about needing about basic trusts, but if you need something more complex, you should get it. Okay. So, for example, if you have a beneficiary who has special needs, who may need special lifelong care, you're going to need a more customized trust for that, to provide the kind of trust that will make sure that that person is taken care of and doesn't lose out on government benefits because of what's coming in the trust. Okay. If you have a home and you want to set it up so that a person can receive the right to occupy that home for life but not own it, then you're going to need a custom trust. Okay. If you need special tax planning, if you have a lot of money, for example, and you need to worry about estate tax, you're going to need a custom trust plan, and those are normally $3,000 and upward. Okay. Now, another point to make is that if you get this trust, if you get a trust, any trust, then it is perfectly okay to have more than one trust. So you can get more in the future if your needs change. Or you can amend your trust, but you can also get just additional trusts as well. Okay, that covers the material that I prepared for you. I went a little bit longer than I expected, but I hope that's very informative for you. Let me. I'm going to pause showing my screen there. And let's see if you want to ask me some questions.
Yeah, thanks, Don. Yeah, if anybody wants to ask any questions, you can put in chat window or you can unmute and ask.
So there is a few questions. Daisy, you're on mute.
No, we are good. Vijay, we can't hear you. Yeah.
I was hearing Daisy, and then suddenly I couldn't.
Yeah. You're muted, Vijay.
Let me ask a few questions.
Yeah,
from
yeah,
the
you
panel.
go ahead.
Yeah, please ask.
Okay. How much does it cost to set up a simple trust? Does it require every year to file taxes for the trust? Maybe that's answered already, but yeah.
Okay, so the first question was how much it costs. If we do our basic trust plan, then it's $1,197, and then there might be some additional charges if you need additional deeds or things like that. And then the second question, I'm not sure I heard.
Does it require every year to file taxes for the trust?
No,
No.
actually, if you have a revocable trust, the IRS doesn't even want you to file separate taxes. They just consider it an extension of you. So you just file your taxes. Anything you have in your trust is just considered you as far as the IRS is concerned. Now, if you end up having an irrevocable trust for some reason, then that's a different matter, and that will have its own tax ID number and so forth.
I think you covered that slide with no ongoing cost, and then there is a one-time basic planning, 1197. And if you have additional properties, 150. So he covered that slide. I'm not sure you missed it. So yeah.
Okay. I think some of these are covered. I think yeah, can you explain a little bit more about a probate process? I think that's covered as well.
Yes, it covered.
What?
Probate process, we covered that, yeah.
At the beginning.
The probate process?
Yeah.
Well, probate involves a lot of different things. It involves filing papers with the courts, getting letters testamentary that authorize a person to take care of all the paperwork and distribute the wealth and so forth. So there's just a lot for the executor to do, and it always ends up involving the court system. So again, I don't want to go into very much detail about it, and I'm not sure I could give you all the detail about it. But it's we do know that it can be cumbersome and it can be long, and so it's nice to avoid. And really, we have will packages available as well, and they're a little bit less money, but they're not a whole lot less money. And so we just think people are better off doing the trusts.
Yeah.
Thank you. If we have maybe this is answered also, do we have to file the will and trust with any legal system, example, local, county, or court?
Yeah, normally no. I think there are a couple states that have a registry of trusts that you can use at your option, so that there's a record of it there. Normally, you don't want to record a trust as a public document with your county, because it makes it a public document, and you don't really want them to see the whole thing. Occasionally, you need to record the certification of trust, which is just a short 2 or 3 page summary of the basic information about the trust. But it doesn't tell them, this person's getting my china, and it doesn't tell them, percentages of who's going to what, or what ages, or things like that. Just the very basic information. Sometimes you need to record that because It's required if you're buying, let's say you're buying a new piece of real estate and you want to title it in the name of your trust. Sometimes the sellers, whoever it is, or the mortgage people, they say, well, we want a public record of this trust, so they'll have you record that. But normally the trust itself, no.
Thank you. Is the property in trust that is left to children taxable when they receive it?
Yes, but the exemption for that is enormously high. So unless your estate exceeds $13.61 million, or twice that for a married couple, there's not going to be any estate tax. There's not going to be any inheritance tax from the federal government. Now, there are some states that charge estate tax, and some of those thresholds are lower. The most draconian one I can think of is, I think, Oregon. Oregon, I think, has a $2 million limit before you start paying estate tax, but that's still a pretty good chunk of money. So there are some states that do it, most states don't. And we need to talk to you about your individual needs, but only if you have really a very large estate.
Thank you. Can the trustee be someone not residing in US, like relatives in a different country?
Yeah, this is an interesting question. I think I'm not sure that there may be some of the states that require that it be a resident of that state, but I think in general it is possible to name someone who lives in a different country as your trustee. However, I think it is very difficult for that trustee to do the job if he's in another country. Now, I recognize we live in an age of miracles. You and I are talking, I'm in Utah, you're somewhere completely different, and we're talking like this, and that's wonderful. And we can do a lot of things electronically, we do a lot of things on the web. I think inevitably a trustee would probably have to show up in person for doing some of the things that need to be done. So my recommendation would be to choose someone who lives in the US if you can.
Thank you. I think somebody is asking to share the WhatsApp link, but I think we will put in the chat, but we'll also share in the follow-up email that you will get, right? So
Yes. Yeah. And also, if anybody wants to have a one-on-one session, 30 minutes free consultation with the Don, you can message me. I can share my number through the email, and then I'm happy to set up based on your availability, based on his availability also. Yeah.
thank you. Will your organization accept MetLife legal plan for creating the estate? Not sure if. Oh, some companies have legal plans. I'm not sure if that is.
They don't. Yeah, they don't take MetLife one. Yeah, but if MetLife covers all the things which Don mentioned, they can take care of it if it is covered from the employer. Yeah, no obligation.
I see. Thank you. Can I own nothing through trust and LLC? I don't know what that means. Can I own nothing? Trust and LLC?
So mean that everything we put inside the trust. So trust owns everything. We don't own anything. That's what they're asking about. Putting everything to the trust, part of the trust, means that the trust owns all assets, but not me.
Right. So ideally, yes, you want to get everything you can into the trust, but that doesn't mean that it has made you invulnerable. That's not my property, so you can't sue me or something like that. With a revocable trust, because you have access to it and because you have control over the trust, it hasn't changed anything about your taxation, and it hasn't changed anything about whether a creditor or a lawsuit can reach you.
But if it is a irrevocable trust, then they can't, right? They can't come after the trust if anybody gets sued.
If it's a revocable trust, the kind that we're talking about now, there are some kinds of irrevocable trusts.
Yes.
Where you're putting things into them and you're making them no longer under your control.
Yes.
Under someone else's control. Then with some of those, in some circumstances, yes, that makes it harder to reach those assets if someone sues you or things like that.
Yeah. So that's a whole asset protection plans, which you can protect your assets by the creditors. Yeah.
There's also there are also limited liability companies or things like that. Well, I organize a lot of those. I usually charge $1,200 to organize an LLC. And when you get one of those, say you own rental properties, you might choose, instead of titling those to your trust, you might choose to put those into a company and then have the trust own the company.
Mm-hmm.
The company creates a corporate veil. It separates the assets inside it from all other assets. So if someone's suing you with regard to that subject matter, they can't reach your personal assets and vice versa.
Yeah.
Thank you. I think that answers this question. If our investment properties are titled under LLC, could those also be trust? So I think that answers.
So Don, you do that too as well, right? Asset
That's
protection.
right. Yeah,
You
yeah.
do
And in
that.
fact, when I organize an LLC, I normally charge basically the same price I charge for a basic plan, so it's $1,200, plus the cost of filing with the state, because I handle that for you. I organize it with and file it with the state government and so forth.
Thank you. Even though you have will with a clear mention of all your assets and distributions, do you still need trust to avoid probate?
Yeah, that's right.
In most cases, yeah. Sometimes if the estate is very small, then you don't. But I think if your estate were as small as that, you probably wouldn't be in this meeting.
And you can also, Don, say that what is the probate cost, right? So it's a cost of the, if they don't do the trust, the probate cost is going to be anywhere range from 4 to 10%, right? Based on the state.
I think you know more about that than I do, actually, Jyoti. But that sounds like a good figure. Yeah.
Yeah.
I don't know whether this was asked. In Texas, if you die without a will or trust, a simple family structure with the married, not divorced, with 2 kids, 18 and 14, what complications come compared to the one that has a will and trust? Assets may be mainly 401k or primary home and all those things. So I don't know, is there any special provision in
Yeah, I'm not
Texas?
sure if I can answer that with specificity with regard to those particular circumstances in Texas, but I can tell you in general, I don't know this off the top of my head what the limit is for an estate that can be administered without probate in Texas, but it's usually very low. It's usually like $25,000 or something. So I hope that's at least somewhat helpful.
Yeah, but better to, pay 1297, take care of, do the trust and take care of that 25,000, right? So.
Yeah.
Okay. Are trusts valid globally or specific to state or country?
Yeah.
So yes and no. They are organized under the specific laws of a state, but they have validity in all the states, right? So a trust that is organized in Texas can own a piece of property in Arkansas, and vice versa. Okay. However, that kind of ends at the borders of the country. Very difficult for a U.S. trust to have any legal meaning in another country over assets that are in that country. It might be easier for it to control personal assets like just money or things like that if they're in another country. Very, very difficult for it to control land in that country.
Yeah, I think that was answered already. Employer offers a similar service, I guess, like Jyoti said, you could try them. Inherit card available in all states.
Yes, that's right. Yeah.
Okay.
Sorry, what available in all states?
They do across all the states, right? So that's what
we do. We can do the basic trusts in all states. It's not always possible for me to do a more advanced trust in all states, depending on what we have in terms of reviewing attorneys. But for these basic trusts, yes.
Can estate be formed in place of trust?
Say that again.
Can estate be formed instead of trust? I didn't get it.
Both are same, right?
Yeah, both are same. That's what I think. Yeah.
Estate planning and trust. Yeah.
It's the same thing. Yeah. And the estate planning combination of whole thing, will, trust, power of attorney for health, HIPAA release, medical directory. That's whole thing comes under the estate plan.
Yeah. So when we do an estate package, we do a trust as part of it. We do those other documents as well. And then besides that, there are things that GLT might be helping you with, like life insurance or things of that nature. So
Yes.
estate planning is just a bigger concept than just, you know, as a will or a trust or whatever. It's all things that you're doing to prepare for the way your wealth is passed on when you go.
Thank you. Who controls age-specific withdrawal rights for your child after you're gone?
That would be your trustee. Yeah.
They
So you named a successor trustee, and you said this person will control it, and then make the decisions to distribute to that child. But when that child reaches certain ages, then he can say, "Hey, trustee, you have to give me this much," and the trustee is obligated to do that. And then when the child reaches finally, you know, the age of might be 30 or whatever, then the trustee has to just hand it over.
I see. Thank you. And how long would that trust document be active? For decades?
Well, it's active as long as it's not covering, as long as not everything in there has happened. So I mean, if all the children have reached the age of 30 and then you've set that as the final age and everything is going out to them, then you're done. And so the trustee can close the trust and it can be over with. Now there's a law in most states called the rule against perpetuities. That has to do with how long something like this can keep going. It's, you know, a life in being plus 21 years is the old traditional one, but in some states it's 300 years or things like that. That's really not going to come into play with a trust of this nature. It's not going to last that long. So,
does the bank have any issues when you move the property from personal name or LLC to the trust?
Very good question. If you're just moving it into a revocable trust, and so far I haven't seen a mortgage company or a bank have any issues with that. It's always a good idea to talk to your bank first and say, hey, I'm about to put this into a revocable trust. I'm still the trustee. So instead of saying John Smith, it's John Smith, trustee of the John Smith Trust. But because of the way those trusts work, they're usually just fine with it. I think it's beyond usually. I don't know of a single case in which they haven't been. So
yeah. Also,
as
they
long
can
as long as we do the proper documentation for it. So
yeah. So in the bank accounts, you can put in the beneficiary contingents beneficiary section. They can put the trust name, right? You don't really need.
Yes. So you can talk to your bank and say, yes, I want this account to be payable to my trust when I'm gone, and they'll probably have you sign something. They'll put a notation on your account. So far, I haven't heard of a bank charging for this. You never know with banks, but so far. And then you do that, and so that when you're gone, the trustee can come and say, these funds belong to the trust. This is what shows on the trustee. This is what shows the original trustees are dead. So give me the funds so I can distribute them. Yeah.
Thank you. What about rental property? Does the rent go to the owner or the trust?
Okay. So if it's owned by the trust directly, then technically money that comes from it is trust money. Okay. But remember, this is a revocable trust. You can do absolutely anything you want with it. So if it belongs to the trust, but you can take that money right out of the trust if you feel like it.
Okay.
Okay. And if the trust is owned by an LLC, if the property is owned by an LLC and then the LLC is owned by the trust, then that property, that rent belongs to the LLC. And of course, the LLC is going to have its own tax ID number, and you're going to deal with that.
Thank you. Who else keeps the official documentation in addition to the owner of the trust?
We have some options for a vault where your documents have some electronic storage, but mostly you want to just take responsibility for that. You want to keep your paper originals, and you want to store them safely in a place that's not likely to burn. So sometimes people get little safes, things like that. If you're going to put it into a bank safe deposit box, be very cautious about that. Be absolutely sure that whoever needs to get into that to get at those papers when you die has access to that box. You do not want to get into a situation where your successor trustee or whoever shows up at the bank says, "Hey, I need to get into the box," and they say, "Well, we need to read the will or the trust first." Well, it's in the box. That can cause a real long problem. So be sure of that.
Very informative webinar. Thanks for that. Thank you. If you made a will and notarized, does the home need to be registered with the county? What happens if you don't have property registered?
Well, if you don't record the new deed for your home with the county, then the ownership of the land and the buildings on it has not changed. So if you own it in your own personal name and you don't record a new deed making it property of you as your trustee rather than just yourself, then it's not in your trust and it has to be probated when you're gone.
Thank you. Why would someone consider an irrevocable trust?
There are a lot of different reasons for doing irrevocable trusts. Sometimes people want to get a certain amount of money set aside that that gets it out of the picture for tax purposes. They can take a big tax deduction by setting up, say, a charitable lead trust where they put money in there and then it pays out to a charity over a certain number of years, and whatever's left reverts back to them. There are lots of different things. That's more complex planning. And it usually is tax related. And for that kind of thing, we'd want to talk to you. I would probably be involving another attorney to talk to you about your needs for that stuff. Anything else?
Yeah. I don't know whether he asked this thing. The next one is, how do you take employers' insurance for covering the cost to make the trust?
No,
I don't think so. Not that I know of. We
Okay.
just take payment usually with a credit card. Yeah.
Okay. And once
the-
that, yeah, go ahead, Vinay.
Once the trust is set, how does properties acquired in the future come under the trust? Do we need to amend the trust?
No, great question. So adding property to the trust or taking property out of the trust is not an amendment to the trust. So you don't need to pay a lawyer like me to make a change in it. If you're buying a new piece of land and you want it to be owned by your trust, you just buy it that way to begin with. You buy it titled in the name of Jane Smith, trustee of the Jane Smith Trust, rather than just the name of Jane Smith. And again, if they have any difficulty with that, they say, wait a minute, trustee, they might require you to record the certification of trust with the county, but that's usually about it. There's usually not a problem, because with a trust of that kind, you're still very much responsible for the mortgage.
So Daisy, till what time do we have? Because there's more questions, right?
Yeah, we can go up to 1:30.
Oh, okay, thank you. Can you talk a bit about estate enhanced tax and how it works with trust? Who's liable for the taxes?
Which kind of tax? Inheritance tax?
Inheritance tax. So I guess
Okay.
the children or whoever is inheriting has to be liable, or?
Yeah. If we're getting into a range of money there where you think inheritance tax is going to come into play, and that's usually interchangeable with the state tax, although sometimes they're slightly different from each other, then we're dealing with a very large amount of money. Okay, we're dealing for a state tax at the federal level. Again, it's more than $13.5 million, and in most states it's certainly in the millions. Okay, if that's the case, then you may very well need some kind of custom planning that might involve an irrevocable trust or some other things, maybe a life insurance trust besides the regular trust or whatever it is. And so we can do that. The responsibility for tax like that, I think it has to come from the estate. So yeah, it would probably come from the trust. As far as I know, yeah. But we'd want to talk to you in a lot of detail about what you need if we're talking about sums of that size. So.
Thank you. For existing property that is in the name of an S corp, can it be moved to the trust?
Well, it can, but you might want to just keep it in the company. You could make the company an asset of the trust. I mean, if you have reasons to move it out of the company, that's fine. Yes, we can just do a new deed and assign it to the trust. But if you want to keep it in your company, you can do that as well, and then you can assign your interest in the company to the trust.
Thank you. You mentioned that one may need a customized trust if one has a lot of money. What is the threshold?
Well, we'll ask you where you are. It depends on the state a little bit, whether there's going to be a state tax kicking in at a lower level of 2 or 3 million or something, or if it's higher. But usually it's much higher than that. However, besides that, there are a lot of other reasons you might need a custom trust, such as having a special needs beneficiary or things of that nature. Or if you want to set up a pet trust. Sometimes people are very, very concerned and very devoted to the idea of making sure that a pet receives a certain amount there's a certain amount of money set aside for the care of that animal if they die. And so that's another thing that would trigger a custom trust. There are, if you want to set up a life estate where you're saying this person can occupy this house under these conditions, but doesn't own the house, still owned by the trust, and then when that person dies or events X, Y, or Z happen, and the person no longer occupies the house, then it reverts back to the trust, and then it is an asset to be divided among the beneficiaries. So those are just a few examples, of things that might require you to have a custom trust. And if you need it, it's the thing to do. You should definitely get it. In the long run, it's not that much more.
Thank you. When I'm not alive, who can ensure that the successor of the trust follows his/her fiduciary duties as laid out in my trust?
Yeah, two good answers for that one. One is, first of all, obviously you want to choose someone you have a lot of confidence in, right? Second, really 3 answers in that case. You can do joint trustees where you say these people serve together, and then if this person can't be the trustee, then it's this person, or if they can't both be trustees, then one of them could be alone or whatever. A third thing is there is an option, and this would be a custom trust, but there is an option for someone called a trust protector. And the trust protector is someone who is either chosen now or can be chosen later on by beneficiaries or whatever. And the trust protector is sort of like a vulture sitting up in the tree and watching this trust all unfold. And if something starts to go wrong, the trust protector can swoop in and fire a trustee or change the terms of the trust or do a lot of things. Very broad power for a trust protector. The idea there is to make sure that there's someone there to help the original intent of the trust be carried out. And so it might not be because someone's doing things wrong. It might be because laws have changed and they need to, or the circumstances have changed, or whatever. But you can do a trust protector. That's one option. And that can also help. You can also do a separate distribution trustee from the regular trustee for certain purposes. Again, that's another thing that would be a custom trust.
Thank you. Who can be the people as successor trustees? Friends, relatives, or any criteria?
Yes. Yes, it can be friends, it can be relatives. Most typically it's a relative. Most people choose that. I want my uncle to be in charge of this until my kids are a certain age, and then they can take control themselves. There are also financial institutions that will do trust work. They will serve as trustees, and sometimes that's a good thing to do, especially a special needs trust. But there are also banks and institutions that in particular won't do that kind. So now obviously if you get a bank or something to be your trustee, then they're going to charge fees. But it just depends on your circumstances. Might be the best way to go. But yes, it can be a friend, it can be relatives, and it can be more than one person at once or not.
How does the state know there's a will or trust?
Well, the state doesn't really need to know necessarily. In the event that you make a record or of your trust, or in the few states that have a registry of trust, if you want to register it with that state registry, then you can. But they don't necessarily need to know that, just like the state doesn't need a copy of everyone's will. Okay, it's just that when you die, then there's this thing that's been established, and they can show that through the documentation, and they can deal with the property accordingly.
Thank you. And suggestion to secure trust document, I think you already mentioned that you offer some service, right, to record or save the documents.
Yeah, vault services.
So
They can
those are, we have some limited services available. I still recommend very strongly that you personally try to ensure that the safety of your original paper documents. So
I'm not sure what this question is asking. Can you give me some real life story, especially Indian simple family living in USA, one marriage and kids? It's not a specific question. It's
so hold on, real life story, especially in USA, and then the sound glitched at the end there. What was the last part?
one marriage and kids. And there's no further question after that. It's just
Oh,
asking,
okay. Well, I mean,
I guess,
They
I've
can
done
how,
a
basic
lot of
plans.
trusts.
Yeah, basic
Yeah, I've done
plan.
a lot of trust plans for people who are not married and have children. I've done a lot of trust plans for people who are married and have no children, and who have children, and all those things. It doesn't fundamentally change things very much. The only difference really is whether you want to do a joint trust with a spouse. But other than that, let's say you're divorced, so you've got children and you've got property of your own. You want to distribute it among children. Now, sometimes when there's a blended family, all right, then you're saying, well, this specifically goes to these children, this specifically goes to these children. That may or may not trigger a custom trust, depending on exactly what it is and how complicated it is. But I mean, yeah, lots of examples of having done that. I mean, we've done hundreds of packages for different kinds of people in all marital situations. So
how can I contact you after this call? So I think in Daisy's follow-up email, you will have the WhatsApp group and phone number for Jyoti. So I guess you can reach. Does home mortgage companies need to be informed about trust? I think it was answered already, right?
yes, and they will be, and it's never a bad idea to check with them before you go forward with the trust. But I haven't seen a mortgage company have a problem with putting something into a revocable trust.
When the dollars assets gets transferred to the kids via trust, the kids will not have to pay any taxes, assuming that the trust is less than 5 million.
Okay, so when assets get transferred to children, the children do not have what?
Do they need to pay tax if it is a like the state tax limit is below $5 million?
Oh, okay.
If they inherit,
Yeah.
do they need to pay
So if a child is inheriting through the trust, it's the same as inheriting any other way.
Yeah.
Okay. And so it's almost always tax free, unless it's a very large amount of money.
Yeah.
Yeah.
Based on the state limit, if they're passing, if the state says you cannot pass $2 million, then whatever they inherit tax they have to pay. If it is within that range, they don't have to pay. Yeah.
Right. And most states don't even have estate tax, so it defaults to the federal estate tax. And unless your estate is more than $13.61 million for one person, or twice that for two people, you don't need to worry about it.
Yeah.
Thank you. If my property is in trust, how does it impact long-term care?
That's a very good question. So this type of trust, a revocable trust, doesn't really impact it at all. Now, there are some special sort of Medicaid trusts, or there are some special which are irrevocable trusts, where you can put funds into something, and then after a certain number of years, those funds won't count in terms of your eligibility for Medicaid. Laws have been getting more, loopholes have been closing. Laws have been getting more stringent about that. So, for example, in Texas, it's in Texas. If you put something into a trust, even if it's an irrevocable trust, if the trustee is even allowed to distribute any of that money back to you, it still counts against you. And if you do these things, if you put something into a trust of this nature, an irrevocable trust, then there's going to be at least a 5-year look-back period. So your state Medicaid organization will say, well, I don't want to just know what you have now. I want to know what you had last year, and the year before that, and the year before that, and the year before that. Going back 5 years, that's going to count against you for Medicaid eligibility. And Medicaid is a welfare program, so it's very heavily means tested. However, interesting developments in some states. In California, they've gotten rid of their asset limit for their Medicaid program, and so a lot of this has become irrelevant in California.
So they can qualify a long-term care if they doesn't count?
Yes,
Oh,
Yeah. So interesting, yeah, interesting things going on there. But it's going to be a state by state thing.
yeah.
How do I know?
Best thing to buy a long-term care just to protect, all these things, right? So it covers anywhere in the world. Yeah. Yeah.
Thank you.
Sorry, go ahead.
How do I know if I need simple or complex trust? So I guess you have a half-hour free consultation
Yeah,
where
we talk to you about that. We figure out what you're really trying to accomplish and whether it's going to be a simple one. I think the majority of clients I talk to end up needing just a simple trust,
Yeah.
but some of the things I've talked about in this meeting are what would trigger a complex trust. So there are others, of course, but
if we have any property sitting out of US, can we make it part of the trust?
No.
probably not.
No.
Yeah, probably. I did address that, but I understand. You keep, it's perfectly okay. Yes, I did mention that, but when you're listening to a presentation like that, it's very normal to miss something. No, we almost certainly cannot make your trust control a piece of property. So, for example, if you own something in South Asia, you're going to need to talk to an attorney there. Okay, so if you have something in India, talk to an Indian attorney. Say, I own this land in such and such province. I want to make sure that it's passed down, and that attorney will probably help you set up some kind of trust arrangement in that country.
Thank you. When I die and the trust becomes irrevocable, I assume automatically, how will the trust get its own tax ID from IRS?
Yeah, that's one of the duties that the trustee is supposed to make sure that happens, to apply for a tax ID number.
I see. Can custodial accounts also go into trust?
Well, you may have stumped me there. I'd have to look into that.
Thank you.
I'm not quite sure. By custodial account, you mean like an account where there is someone who is you have a guardianship over like an elderly person or something like that? Is that what we mean?
I will check for if they put a follow-up question.
Because sometimes you can establish a trust. Now again, this would be a custom trust, but sometimes you can establish a trust for another person if that person has given you authority. If you have a durable power of attorney that says you have the power to do that, then you can set up a trust for that person and put that person's assets into it.
But if it's a UTMA kind of account where it automatically goes to the beneficiary once they are achieve the age, so that could be, can that be in the trust or?
Yes, so it depends. You can, there are things that can pass to people outside of probate without going into your trust, and that's an example of one.
Okay.
But in your trust, you've set up special conditions maybe that say, okay, a child can have this much control at age 21, this much control at age 25, and so forth. That's not going to apply under that. It's going to be under a whole separate thing, the Uniform Transfers to Minors Act. So if instead you direct it through your trust, then you have more control over the terms.
The person replied, yes, minor accounts. I guess that's what he meant by custodial accounts.
Yeah.
Yes, yeah. So if you have an account that is in the name of a child and it's for that child's benefit, then yes, you can direct it to your trust as long as you have, yeah. And then you can, if you want to say funds from such and such account at such and such bank will be distributed to this child under the following terms, then you can do that in a trust. And if you're getting that specific with things, you may or may not need to do a custom trust.
And does that include those 529 accounts too, where we bill for the child's education?
Oh, not exactly, but there is a way for funds like that to be sent to flow through it. I don't remember all the details on that. We'd have to talk to you.
Okay.
Anyway, yeah.
If we have charitable lead trust, can it be nested under the simple revocable trust or have it be treated separately in an event of my and my spouse's demise?
Yeah, a charitable lead trust is its own institution. It's its own trust, right? So it's separate from whatever other trust you might have, but you can set that up and say, I'm going to take a big tax break this year by putting a bunch of money into this charitable lead trust. This trust is going to pay out to such and such charity for the next 20 years. And then when it's gone, when those 20 years are over, whatever's left in there, because it's probably been earning, right, then whatever's left is going to revert back to me. And you can say it reverts back to this trust if you want.
I see. Thank you. If irrevocable trust is vulnerable to get sued by others, should we take an umbrella policy?
I never advise people against getting insurance. I think insurance is a very good thing to have. If you're, even if you're going, let's say you have rental properties and you're going to organize an LLC, that's going to isolate those assets, but it's still a good idea to have very good liability insurance on those properties, because that's your first line of defense before you even get to worrying about what assets someone can reach, right? And an umbrella policy can be a great thing. If you have your homeowners and your car insurance and various other kinds of insurance set up to the proper limits, then the company that you insure those things with may very well offer an umbrella policy that will say, above and beyond those limits, we will pay up to this amount. And it doesn't matter which source of liability it comes from, it covers all those things. That can be a really good thing to have. And so I think, talking to Jyoti or whoever your insurance agent is going to be about that, never a bad idea to find out about it and make a judgment about how much it would cost. But it's probably more affordable than you think. So,
If one has will and trust but did not move home to trust name, and if they die, will this go to probate?
yes. Yeah.
I see. Say an LLC related
That's
to rental.
probably your biggest asset, and it doesn't make a lot of sense not to put it in your trust. You want to, if you're trying to avoid probate, but for goodness sake, please put it in your trust. Yeah.
Okay. And I guess this is answered already. To avoid, do I need trust if I have one property and financial accounts, bank, retirement shares, etc.?
Well, I recommend it. Yeah, I recommend it just because you can direct all those things into your trust, and then it will avoid probate. That is the minimum benefit that it's going to give you, is that it will avoid probate, and that's pretty nice. And then beyond that, there may be other benefits, but even if it's nothing else, just the avoidance of probate can be really helpful.
Can we include assets owned in other? Oh, yeah, that's already answered. For all my properties in a trust, how does it impact? That's already answered. What if the trustee dies before you? I guess you select another trustee.
Yeah, so I recommend for trustee or for any position that you're naming someone to do something, name at least one backup. Okay, so my trustee is going to be John. If John dies or can't serve as trustee, then it's going to be Jane. If Jane can't do it, then it's Robert, and so forth. You can set it up that way. You can also do more complex things. If it gets complex enough, it might require a custom trust. So if you're saying, like, these three people are the trustees jointly, and then if this one dies, then it's this person who replaces them. But if it's this one who dies, then it's this other person who replaces them. That kind of thing is probably going to end up requiring customization of language. But for if you just want to do like a simple joint trusteeship where you say these two people work together, and then if one of them dies, the other one can serve alone, or this other person comes in. You can do that, or you can say, it's A. If it's not A, it's B. If it's not B, it's C. But yes, give yourself some backups and make sure that they're not all old people. So.
Yeah, and I think the question is,
you can make your mind about those things down the road.
Yeah.
You can your trust. You can say, I don't want this person to be my trustee anymore. I've lost his confidence, or he's dead, or whatever it might be. You can go ahead and do an amendment to your trust.
Right. That's what I mean. When you're alive, you can change the trustees.
Yeah.
As irrevocable. Okay.
Yeah.
If others can still sue the trust, what is the advantage of owning a revocable trust other than avoiding a probate?
I'd say besides the avoidance of probate, you have a little bit more flexibility with things like setting terms for when a child can receive something and having it stretched out. By the way, it doesn't have to be a child; it can be an adult. You still don't want that person to receive it all at once, and you can associate it with ages, or you can just say numbers of years. This person can take out up to 10% after 2 years, can take out up to a ninth of what's left after 2 more years, things like that. setting terms like that. So those are probably the main advantages.
Thank you. Do the deed of the property
It's
needs
just
to
a
be
lot easier to do that under a trust than it would be under a will. Will be a very complicated and strange will. So.
Thank you. Does the deed of property needs to be amended to transfer the property from individual to the trust?
Yes, we do a new deed. It's usually just a quick claim deed that we prepare for you. You sign it and then you go and record it with the county. Say whatever I own, whatever interest I had in this property now goes to me as trustee.
Okay. How do you sell a house which is in the trust?
Oh, well, you just sell it, right? You just sell it like you would any other house. You say, here, this house is for sale. And then when the money comes in, that money belongs to the trust. So you can put it in your trust bank account, or you can do absolutely anything else you want to do with it. You can withdraw it from the trust because you can do that. It's a revocable trust, whatever you feel like. You can buy a new piece of property with it. So yeah, just entirely up to you.
What is the downfall of deed on death? I'm not sure. What is the downfall of deed on death?
What is the downfall deed on death?
Yeah, downfall of deed on death.
I'm not sure that I understand that question. I don't think I can be very helpful with that.
Okay, maybe they can put some more.
Yeah.
Can't you just add a deed on death instead of putting things in a trust?
No,
That's
deed.
what-
Deed is a house, transferring the house to the trust. That's a deed transferring.
Yeah. There are other things called like ladybird deeds and things where you can set up a deed and have it go to someone. But I recommend usually just establishing the trust and deeding it to the trust. It's just as simple, and it doesn't usually take away any advantages you have. It doesn't interfere with your homestead exemption, for example. So you're fine.
How long is the process? Does the process to take up a simple trust take? 2 weeks, 1 month?
Okay, yeah, that's a very good question. That's going to depend in part on how long it takes to get the deeds. And that's going to vary a lot depending on the state and county that we're dealing with. There are counties in Virginia that will take forever if they can. Sometimes we even ask the client to provide a copy of the deed, and that speeds things up for us. But we're dealing with county and state governments in doing that. So that's the biggest factor. When I get someone's information, I usually have their documents drafted in less than 2 weeks, and they're ready for review. But it's that other process of getting the deed that sometimes takes longer, and so we usually tell people, like 4 to 6 weeks. But it's kind of unpredictable. But if you already have a copy of your deed and you provide that can speed things up. And sometimes we're able to do it very fast, especially if you don't even own real estate, then that makes it really fast. As long as you read through it and you approve it, then you're ready to go. So.
Yeah, we are nearing the end of time. Vinay, just 2 more questions.
Okay. Desi.
Yeah, go ahead. I just want to have last 2 questions. That's all.
Okay. Wow.
Yeah, most of them they're repeating the same questions over and over again.
Yeah.
And
Anyway,
that's normal. Something's going on. Questions.
Anyway, everybody's situation different. Anyway, no obligation. 30 minutes
Exactly.
consultation.
Yeah,
We can
exactly.
talk. It's. I think it's more. One-on-one will help those questions, right? Because most generically covered. So yeah. And thanks Don's time for appreciating on the weekend, and thanks to all of you to attending.
Thank you. This is the first attorney I see work on a weekend, so.
I know.
Well, I have to warn you. I normally don't. And if someone is looking for a one-on-one appointment with me, those are almost never available on a weekend. Okay.
Yes. That's what. When I was trying to set up with Jyoti, I asked him, is it going to be a weekend? Is it okay with him? And he said, yeah, not Sunday, but Saturday is okay.
Yeah.
Kept saying, yeah.
But here I'm dealing with 60+ people, so.
Yeah, thank you. Thank you. Thank you, everybody. We had a very good audience and a lot of good questions. And yeah, we cannot thank you enough, Don and Jyoti, for your time, efforts, and your patience in answering even the simplest of the questions, without smirking. But
I wish they were
thanks.
all easy.
Yeah. Okay.
All right. Thank you. Thank you all very much.
Thank you all, and thank you, our audience. We would like to continue talking about such topics in the future, and so please let us know what you would like to hear, and also, in the feedback questions, there are some topics what would you prefer to listen to next time and all. So we will try to take those things and then go for it. We will do periodically such personal finance sessions along with the other ones. And so please help us out, support, and then we will see you bring another good session next time.
Sure.
But however, we are continuing our sessions, switching a bit, and we have 2 sessions programmed in July for the benefit and welfare of all our teens and their resilience by a couple of accomplished professional motivational speaker and Gen Z expert, as well as the family and therapy specialist. So please watch for our announcements and emails, and then register and please attend. And we will see you the next time. But Don, thank you so much for your time and being with us. Hopefully, Jyoti, you send me or Don send me the presentation slide also, so that I can include that. And then you also send me all the contact information and WhatsApp information. So I will include that tomorrow's one. And thank you, everybody, for attending. And thank you. We'll see you again next time.
Thank you. Thanks, everyone. Have a nice weekend. Thanks, Vijay.
Yeah, thank you.